All right. Hello everyone, and welcome to EBC learning session on competition law during COVID-19 and after. I'm Vijetri Roy, and I'm an instructional designer at EBC Learning. Now, for all those who are not aware of EBC Learning, EBC Learning. I'm really sorry for that. It was going on live in the background. Um, so this session is also brought to you by EBC Learning, and for those who are not aware, I would just repeat, EBC Learning is EBC's educational initiative where we provide on-demand legal education for everyone. And our objectives at EBC Learning are to help remove hurdles to legal education, to empower you to make life-changing moves, and to help you learn and win. Now, our purpose of bringing all these sessions to you is also a part of our initiative and objective at EBC Learning. That is, we are bringing up a lot of these sessions, and today is a very special session because we have a panel discussion today on this topic of competition law during COVID-19 and after. For those our participants who are not aware, we have all our courses that are available on our online official platform, which is ebclearning.com. And this session right now, as you can probably see on your screen, is live on YouTube. And of course, later on, if you wish to revisit this particular session, you can do that because it would continue to be available on our official channel on YouTube as well, which is again EBC Learning. Now, for all our participants today, thank you for joining in, and please feel free to post your questions and queries for our distinguished panel today on the chat tab, which is at the bottom of your app screen. And of course, I would love to encourage all of you to have a look at our platform once this session is done. And also, please share whatever your experience was today during this session with your friends and family, of course, on social media. Now, without taking much of your time, I would like to just quickly tell you what exactly are we going to expect from this session today. Now, as you all know that COVID-19 and of course the lockdown have brought the markets to a standstill, and that might of course impact the market dynamics for some time to come. And on this backdrop and taking all these things into consideration, it was decided by our distinguished panelists to come up with this particular session where I'm sure a lot of discussions would definitely take place on, of course, CCI's approach and role and any deviations in enforcement policy, then industrial concerns, or what sectors are getting affected and what would be the best practices, then issues in market assessment relating to say agreements, abuse of dominance, and combination analysis, and of course economic and legal arguments and defenses. Very quickly, I would like to introduce our panel moderator, Mr. Anand Venkatramani. Hi, Anand. Welcome to today's session. And Anand is a dual qualified lawyer who is practicing in Delhi, and he's focusing on commercial litigation and competition law. He has been engaged in competition law since 2015, which includes 2 years in competition team at Shardul Amarchand Mangaldas and Company. Prior to his LLM from New York University in 2014, he has also worked with Lakshmi Kumaran and Sridharan's indirect tax litigation team between 2011 and 2013. Now, with this, I would request Anand to take over the session, and he would be introducing our guests and our panelists and speakers, and we will then have the session. And again, for the participants, please feel free to post your questions and queries, which would be taken up towards the end of this session. Now it's over to you, Anand.
Thank you, Vijetri, and thanks a lot for EBC Learning to host this webinar on this extremely topical issue. As Vijetri correctly said, the COVID-19 has brought many industries to a complete standstill. The full economic blow has only yet begun to be felt both nationally and globally. And it will certainly, as she said, impact market dynamics for some time to come. While the CCI has issued a helpful advisory, I believe many questions remain. And I think this will resonate with some of the panelists as well. To ask and answer some of these questions, we have with us today a very diverse panel of stalwarts in their respective roles and professions. Whilst none of them really need an introduction, I think not doing so would be disservice to their standing. Our keynote speaker is Dr. Geeta Gauri, Distinguished Fellow of India Development Foundation and a member of the CCI from 2009 to 2014. As a member of the CCI, Dr. Gauri's priority was on developing jurisprudence based on economic analysis. Her dissenting opinion in the Hiranandani case is well known in this respect. She's an author of several books, and she's currently working on the area of competition law and standard essential patents. We also have with us Mr. John Handel, who's the National Practice Head for Competition Law at Shardul Amarchand. He is a specialist competition and regulatory lawyer with an extensive experience of over 35 years. Bringing his European and international experience to bear, he has worked in a number of matters before the CCI, the appellate tribunals, other courts, merger notification, antitrust investigations, leniency, cartels, and alleged abuse of dominance. John also actively advises companies regularly on compliance programs and on preparing for dawn raids. Next, we have Mr. Rajshekhar Rao, who is no stranger in the field of competition litigation in India. Mr. Rao is an arguing counsel in Delhi whose principal areas of practice are commercial litigation, arbitration, and competition law. He graduated from NLSIU Bangalore in 1999 as a gold medalist and joined the chambers of Miss Indu Malhotra, as her ladyship then was. From 2001 to 2006, he worked with Mr. Gopal Subramaniam, senior advocate, and he started his individual practice in 2006. His tryst with arguing competition matters has continued since 2013, for the last 7 years. Finally, we have Satvik. Satvik is a competition economist and has been advising public and private sector clients in Europe and Asia on antitrust and regulatory matters since 2008. He has worked at a leading law firm and several economic consultancies before founding Sapient Econ. In addition to conducting economic analysis, he has drafted legal submissions and opinions and advised on every Indian Phase 2 merger since 2017 and on 2 iconic Phase 2 mergers before the European Commission. I may also add that Satvik is a professional actor who has played roles in both the big and small screen as well as in theater, and is also a strong voice for the LGBTQ community. In this webinar, these power-packed panelists would address the CCI's approach and role and whether any deviations are expected or even warranted. The panelists would also discuss how to navigate the substantive analysis of antitrust, as well as merger control issues, market assessment, market power, etc., for instance, and talk about the analytical tools that may be employed by which may be relevant for the COVID period and perhaps for the period to come after that as well. The panelists may also offer some pointers perhaps on best practices. Just as another note to the viewers, to keep this more engaging, after Dr. Gauri and John Handel have given their views, we can take up a couple of questions from the viewers, which, as Bijayatri mentioned, can be typed in the chat box. We will then move on to Satvik and finally to Mr. Rao, after which, again, we will be taking questions to the panel. Getting straight to the Competition Authority's role, I quote Neelie Kroes, the former European Commissioner for Competition, who had this to say about competition policy in the wake of the 2008 global economic recession, often popularly called the Great Recession. And I quote, "If I may quickly mention the issue of so-called crisis cartels, there may be many temptations in 2009 to cut corners, but encouraging cartelists and others would be guaranteeing disaster. It would drag down recovery, increase consumer harm, and create more cartel cases in the future. No one wins. Today's softness is tomorrow's nightmare." Reflecting on this message and more, I now invite Dr. Geeta Gauri to give her address from a regulator's perspective and what the CCI may or ought to do. Thank you.
Thank you, Anand. And thank you, EBC, for giving me this opportunity to talk about the COVID-19 adversaries. And it's going to be entirely from a commissioner's perspective. And I will look into the two important advisories that have come out with deal with all aspects that are related to antitrust business, and then decide what should be done or what could be done. I think the first most important thing is that these are very unusual times, and perhaps we need to take a lot of unusual steps. And when I say we, I'm saying the Competition Commission of India. I'm talking as a regulator because I've been a regulator in the electricity sector. So there is a tendency to personalize the use of the word we than to say CCI alone. But let me go further on this, and I think it's a very vast subject. And I shall try to limit myself because I think we all, if I'm not wrong, have about 12 minutes to cover this subject. Now, how would I look at the COVID-19 and competition law? That is, what is it that is post-COVID and what it is pre-COVID, entirely on market dynamics? Is it causing a change on market dynamics? Is it going to mean a complete review on how we approach them, and what is the situation? Now, when one looks at it this way, I want to put my arguments into two criteria: lockdown, lockout. I use the word lockdown and lockout because we do have a lockdown, and hopefully in another week it should be done, and hopefully coronavirus should leave us. This is always a hope that one lives with. But at the same time, I think the lockout is also equally critical. And the lockout is not just an outcome of the lockdown. It's a lockout because economic growth has been falling for a very long time, over a year. So when one looks at it, one has to see what is it the market requires to revive. And there is an interrelationship between lockdown and lockout. So when I look at it as a free trade market regulator, CCI, there are two aspects of it that are in this lockdown, lockout framework. One is, what is the impact on the dynamics of markets? I will analyze and put it forward as quickly as possible. My other colleagues will give in from their experience from the other side of the table. And I'll also talk about implications of this post-COVID advisory on more recent of concerns that are going to come up. This will be related to the emerging platforms, emerging markets, the platform markets, and the market for ideas, where there's a tendency for concentration, and how perhaps we have to rethink some of the concepts that are part of antitrust literature, both in terms of abuse and the tools used. Now, it is interesting that when I say post-COVID, I'm using two ironical situations. The irony of it is one is trying to be cautious because the market is still dampened, yet at the same time, I will suggest being a little bit more aggressive because the lockout has to pick up. The economy has to be picked up. And this is a kind of thing that Competition Commission always treads. It walks a delicate balance between being cautious and between being proactive. And so when I ask and look at the advisories, I'll concentrate really on three advisories. Advisories of 30th March, advisories of 14th April, and the advisory of 19th April, and ask the question. I use the two words that all lawyers love to use. Were they necessary? Were they proportionate? I think this is something that I'm going to try and get into it. And in my opinion, as an independent regulator of markets and of fair trade, CCI's role becomes very critical. Now let's go on, and if the slides can be put on, look at the advisory of 30th March. I don't know if the slides are on because
I'll just turn them on. Just one second.
Yeah. So while she's on, it's extremely interesting and relevant to note that you know, when you have this situation where you are putting out a notification.
Is it visible?
All the, yeah, that's that's the one, right. Now, can we go on to the next slide? Because this is only a title.
Yes.
Can I click it myself? Yeah. Well, when you look at it, I have already dealt with the fact that lockdown is pandemic, lockout is economic revival, and the CCI has a major role to play on it. And let me get on to the next slide, which is the one that I will start with. Is the internet connection all right now? Yes. Now, what is it that is so interesting about this slide? This is a regulation or an advisory that has come out extending the green channel. The green channel advisory, green channel response to the combination regulation. So although it has come out as a COVID advisory, they say that all filings have to be electronic, and all merger filings and all filings which are to deal with the question of acquisitions will then have to go and look at it pure 5A regulation of 2009. So it's really an extension. It's nothing new about it, but it's just that now everything is going to be looked at electronically. And the fourth is that anything that has to deal with the other sections of the Act, that is abuse of dominance or agreements, can also be filed electronically. Let me spend a little bit more time on this question of the green channel. When you look at the green channel, and it doesn't get into the next slide. Yeah. See, the green channel, what is the green channel? Now, the green channel, when you look at it, and you look at it from the combination framework, and you are wanting to understand what it means, is that the green channel says that there should be no links, upward links or downward links for any merger to be cleared. There are concerns of what in antitrust language means horizontal and vertical lapse. So they're going to allow for all mergers which are almost antiseptic. That is, they have no links at all, and therefore they can be cleared immediately. Now, this is the situation that one is looking at it. And if I go a little further, there would be a separate channel, there'd be a separate slide that I have put up on channel 3, on schedule 3. And if you look at schedule 3, what is the problem with schedule 3? It came up in combination regulation. It is an extension of a regulation done in 260 and an extension of the mother of all regulations on combinations of 2000. Because the most important thing when we did the 2011 regulation is that you have to create trust with the market, with investors. And if you're going to create trust with investors, there should be nothing that is left to uncertainty. But look at Schedule 3 of Combination 16, because Schedule 3 of Combination 16 says, considering all plausible alternative market definitions, which means that different the market can be defined apart from the one of substitution. And the entity should not hold shares or any control interest. That is why, right, a few seconds ago, I said, you're looking at mergers which are absolutely antiseptic. They have nothing in them. And the 7 mergers cleared, one is, I think, IDBI AMC Trust with Muthoot Finance. Then they have one on the boards. These have no links at all. The Schedule 3 also goes on to say, do not produce or provide identical or substitutable products. That means that anything that is substitutable will not be accepted. And it also means that you're looking at alternate market definitions. In any activity relating to production, supply, distribution, storage, sales, services, or trade, which are at different stages or levels of production. This same argument will come into the second advisory, that is on the question of the supply chain. And the last point that comes up is similar, that is, they're not engaged in any activity which are complementary to each other. Now, I would like to bring this up when I'm dealing in the end, after I have looked at the advisories, that the new emergent market deals with substitutes which are not price rated. It deals with complements because it is dealing with patents. Then what is it that the market that we are going to relate these COVID advisories? Now, having stated this, let us try and see that how would CCI as a gatekeeper for investment look at it. And again, let me remind you that my looking at all these advisories are in the context of the lockdown and lockout. So if I go back to the previous slide, Vijayatra, can we get to the previous slide? I have stated here, green channel is a guide known for detracting and not for attracting much needed investment. And this is where I'm saying that CCI, while it has to be very careful and cautious, it also must take very proactive steps, because what this country right now needs is a lot of investment that comes in. And my own thing is that the green channel combination regulation creates uncertainty. It dampens any kind of investment. And what is the uncertainty? It is on the question of the risk of interpretation in defining the market, defining the product. It is up to the CCI to accept the authenticity of all the documents that have been stated or to reject it. And that there should be no horizontal and overlaps. And it is essentially, while all the documents have to be failed, the uncertainty that gets created arises from the fact that it is the understanding of CCI, not the documents, on all these that have been stated out in Schedule 3. Now, let's go a little further, skip the green channel, go into what my suggestion in this case of what we have to do. And I would suggest that, since there are so many powers with the CCI, why not just extend the collaboration to a more open acquisition regime to attract foreign investment in technology? Now, this is the time, because there are several foreign companies seeking venues to come in, and several digital companies, high-tech companies, pharmaceuticals would be interested in coming in. And CCI has the powers and the ability to be able to examine each of these cases by themselves and see what is the outcome. Not only that, but suppose there is a case of monopolization, a year later, CCI can again intervene to see whether the merger was appropriate or not. Not only that, under Section 4, it can be taken up under abuse of dominance. So it's, the point that I'm trying to make is that the present Act has so many options open to CCI to take it up. Now, how do you remove uncertainty? And this, I think, would require some amount of guidelines to be forthcoming. So when you are talking about all the uncertainties that this advisory has come up with, it is important for CCI now to think of guidelines that can remove uncertainty. I'm not too sure how they. The last point which I'd like to bring up, because there has been a lot of debate in European Commission, I've been looking at it, is on the question of failing firms. Now, this is an area one needs to tread very carefully, and I am personally not very comfortable of allowing for mergers or acquisitions when there are failing firms involved in it, because we don't know if it is a genuine failing firm or is it a failing firm because of COVID, and it is something that antitrust in some countries have been more proactive, taken a cautious approach, and I think it's better to stay with the cautious approach. So here I'm again coming up with a situation of caution, but also proactive. It's a delicate balance that CCI has to work out. Let me take the next advisory that comes up. Do I have another 10 minutes? The next advisory is the one that came up on the 19th of April. In the next slide, you will see it very clearly. This is with regard to the supply chain. Now, what is the supply chain? This deals with horizontal agreements. It deals with vertical agreements. New supplies have to be created, in healthcare and pharma products and in essential commodities. But when the permission will be granted and only on the condition that some sort of data will be shared. So the consumers, the people who have these new links that are being forged, they could share data on stock levels. They could share data on timing of operations. They could share data on distribution network, infrastructure, transport, logistics, or they can share data on R&D. If I looked at the Green Channel and made the comment that the advisory that came out on Green Channel of 13th March was not necessary because combination regulations have to go through the whole process. When I look at the supply channel, I will again have to look at it whether it is necessary or not necessary. As a regulator, what would I look at? And let's go on to the next slide. As a regulator, the most worrying part is that supply chain forges new links, new businesses. You're going to come up with new cartels. Cartels are always a concern. You know, it's a delicate balance between collaborate and compete. And I go back to my onion cartel, which was the one case where I didn't give a full dissent order, but I argued for want of data. You know, the APMC has now been removed, very progressive step. ECA has been removed, very progressive step. But what was the onion cartel? That is, the traders who bought the onions at the primary mandi had link with traders in further markets, had link with the transporters in Yelahanka, which brought the product to Delhi, which had links again. So now you have a supply chain and advisory, which is forging new links. So you're creating a base where they're sharing information, not price information, because the government had decided to put a cap on price gouging. So perhaps we will say there is no price gouging because there's a cap, but no one has defined in the advisory, apart from the cap on say vegetables or some fruits, or not even that. I think it's a cap on equipment, protective gear. You can have price gouging in very different ways. What are the essential commodities? How do you decide what are the essential commodities? So we're really treading on very slippery ground and forging new links. So what could happen is you could see a lot of perverse outcomes. You can see small firms getting linked up, and they have very important information that pertains to the question of stocks, pertains to the distribution links, which pertains to owning the R&D of a new genetic or generic drug material, or the API that's involved in it. And therefore, when I looked at a lot of the literature or what is happening in the other countries, the drugs in that area is something that is quite a bit of a worry that has come. So there are perverse outcomes by creating supply links. And I think there are two of them which I would like to point out before I go into the last section, is that when you forge new links, you might find that it is small firms which are controlling the market. It may not be large firms. It could be small data firms, small technology firms. You know, you have a funny kind of Bertrand solution, not the one where he talked about a dominant and a leading firm. Or you could also have a situation where you have something, modalities of, what the supply chain does it. It says that any sort of collaboration will be tolerated if accepted. Then what are the guidelines for those are the conditions where the modalities of acceptance are laid out? There's another issue that comes up, because if these are small firms that are controlling the market, then who's asserting the power? Then there's also the problem in India that you have different names and different association grouping together. Right now you have Zomato, who are willing to deliver anything apart from what Zomato and Swiggy also do. But any new association, any new link is something that is going to come up. Now, having stated my basic worries that have to deal with the COVID advisory, and whether it was necessary for CCI to have given these advisories is very difficult, because you see, if CCI hadn't given the advisories, everyone would have pointed out to Europe and said, look, Europe has come out with so many advisories, why hasn't India? But at the same time, they have displayed a certain amount of caution. But I think now what is important is perhaps it is necessary to become much more active in terms of attracting investment coming in. Can we go on to the slide, and what would be the points that I have made on suggestion? More vigilance. Old cartels and mandis do not die easily. You're only helping them to form new links. So CCI has to be much more alert. Although there is price cap now, perhaps it is necessary, we had talked about it during my time, of creating a separate unit of price tracking of some of the essential commodities. And now if you're going to talk about some of the essential commodities of price tracking, in the cement cartel, we had removed the Cement Manufacturing Association from sharing information. So the price tracking mechanism should be an internal one with the Government of India. And this can be done very easily so that there's a way of knowing where some sort of spike is coming up or what is an uncomfortable, because in a lot of essential commodities, the spike may be only for a week or maybe that would require investigation. Therefore, I have also gone on to say, I have stated earlier also, the market power of small firms, guidelines on what modalities of collaboration will be tolerated. It is also important to have ownership identification, because with supply chains, new links coming up, there is always the worry of common ownership. Although in India, we have said in terms of control and common ownership, it will not be more than 25. And then what will be allowed control is when it's 50. But these are very difficult things to work out where business are concerned. Now, let me go on to the last suggestions before I take up it's not a suggestion, why I wanted to bring this up in terms of what I call as competition post-COVID issues. See, the present that we are talking about is more in terms of platform markets, more in terms of market for ideas. And as an economist, I'm sure Satvik, another economist, will agree that the present act and also the new act is being framed like the COVID advisories in what in economics is known as a product market, which is more or less binaries. You know, the binary of competition and a binary of monopolistic competition. And we did a lot about it on what do you do with monopolistic competition. And we had different models of seeing whether this would be a monopolistic competition would lead to assertion of power, or are there any competitive constraints that are operating. But now what happens is greater attention has to be paid to platform, because that is what Channel 3 Green Channel suggests. And when I talk about platform markets, there are so many interlinkages between which side you define a market. The way that the relevant market was defined, say, in the Google case, or the way the relevant market is now being defined in case of, some of the other things that deal with the internet, because they're not only two-sided, but they're multiple-sided. And price usage of matrices like SNP or the learner index don't have much usage, nor can we go into quality. This is a challenge for all competition authorities to look into. And I'm afraid that while we do learn from other competition authorities, the Indian consumer and the uniqueness of the Indian market has to come in. It's not that we can just borrow straight away and take a case that's coming up. There's also another area which I think we should look into, is on the question of the strategic games that new links that are forged are going to come up. I think I have spoken a lot. It is a delicate balance. It's a delicate balance between caution and between proactive. Now, I think we will have to be more proactive, and we'll have to understand new emergent markets. Standard essential patents, they are concentrated markets. We had the case of Micromax and Ericsson, and these deal with complementaries. If you're dealing with markets on platforms, they have nothing to do with substitutes on price basis. They are dealing with verticals. So are you going to look at competition between verticals? There are a whole set of issues, and the Competition Commission will, I'm sure, be noting this, because there have been a series of think tanks on this subject, and they'll go ahead. But right now, to answer the question that I posed to myself when I was asked to speak, and this is coming at the end of the lockdown, were the advisories necessary? I don't think so. I think there's enough within the Act and the regulations to continue. Were they proportional? You know, it's a question of just showing you're around and you're active. I think the task ahead is much more difficult than the COVID advisories. So let me stop here and ask my other co-panelists, who I have not talked about the other countries. I have not talked in detail about economics. I've not talked in the way that lawyers look at it. But if you ask my question, I would say that these are difficult times, these are unusual times, and they require unusual approaches. And that is what the CCI should keep in mind.
Thank you, Dr. Gauri. She has made an important point regarding small firms affecting the supply chain links, which also raises the questions on how to deal with price increases, perhaps, and price gouging, which are short of any active agreement amongst competitors and more of a parallel conduct, and how the CCI, whether it has the tools to even deal with that or not. And ma'am, your point on market definition is also well taken. Adding, it's perhaps exacerbated by the fact that there's an asymmetric impact. COVID-19 has had an asymmetric impact across different sectors, and some of the standard notions about market definition and assessment of market power may also need revisiting. And disruptions in demand and supply, as mentioned, may also prompt certain horizontal and vertical responses which may need to be assessed carefully. I now invite John to talk about the challenges in competition enforcement and the interpretation and adequacy of the CCI's advisory, and any words of caution that he may want to, if at all, give to the industry. Over to you, John.
Thank you. I always seem to speak after Dr. Gauri. I don't understand why this is the case. And I always find it very difficult to speak after Dr. Gauri because she raises such interesting and challenging questions. I'm not going to respond to her points. It's not the purpose of me to reply to what she said. But I would like to make one point initially, and maybe pick up a few other points as I go ahead. A lot of the concerns that Dr. Gauri has addressed are not created, but may be exacerbated by COVID-19. A lot of attention is placed on platforms. Those problems have been existing, as you appreciate, for quite a long time. They may be accelerated or may need to be considered more carefully because of COVID, but they're not COVID-induced problems. We are undoubtedly in hard and challenging times. There have been massive economic shocks. What the European Commission has said in its own communication on a temporary framework for assessing antitrust issues is maybe blunter than most competition agency assessments. The outbreak is a major and unprecedented shock at the global and union level. The disruption of supply chains has resulted in a general supply shock. This is combined with an asymmetric demand shock. In some areas close to my heart, such as air travel, there has been an abrupt decline in demand, whilst in others, hand sanitizers and protective clothing, for example, there's been a steep rise in demand. It's not clear for how long these shocks will last. Much depends on the path taken by the virus, the approach of government, and the attitude of the individual. Today, we're focusing on competition and its application at a time of COVID-19 and after. I'm going to focus on now rather than after. There's a lot of crystal ball gazing. Dr. Gauri has done it very well. Others may be able to crystal ball gaze better than I. Satvik, I know, is a great crystal ball gazer. But in the context of COVID-19, competition authorities face a number of challenges. Let me just mention a few. They've actually been mentioned largely by Dr. Gauri as well. First, how competition agencies can operate effectively during the epidemic. Second, how to deal with competitor coordination, which is going to be the centerpiece of what I'll be talking about. Third, how to deal with anti-competitive behavior, which may be used to counter the effects of COVID-19, cartel activity, vertical restraints such as resale price maintenance, or abuse of dominant position. Next, how to assess mergers. In particular, how to address arguments on failing firms' efficiencies and the contribution made to economic development. I think it's safe to say that Satvik will say something on this, so I won't spend very much time on mergers now. I want to say something about the CCI operating in the pandemic. I know that there are issues about the Green Channel and the guidance, but I would like to say that the CCI has remained as open for business as it can in the circumstances. If people cannot come to office, they work from home. We have seen this in working with the CCI over the past few weeks. They are very active. They are very anxious to engage. Now, there are limits on external engagement. Outside visitors cannot come. Critical procedural elements such as hearings and other compliances have had to be suspended, which means that Paul, Rajshekar, and Anand will be doing a lot more work in a month's or time when the procedures start reopening. But the CCI has since mid-April accepted that complaints alleging breaches of Section 3 and Section 4 may be filed electronically, and what is tempted to say in today's world, not before time. Likewise, we can now file merger notifications electronically. That's always been a possibility, but not exercised. Now it's become a reality. Pre-filing consultations may take place by video conference. That could have been introduced a while ago. It's good it's been introduced now, particularly when you have clients who are overseas who no longer have to travel to take part in video conferences with the CCI. The CCI has said it will endeavour to process new and pending cases subject to the availability of necessary information and material. It's issued approval orders in merger cases, and it has made a number of orders in the enforcement field. In short, the CCI is, as far as it can be, open for business. I just felt it's important to defend the CCI if there's been any suggestions that they haven't acted as openly as well as they can in a very, very difficult time. Now, let's go to the nub of this, competitor coordination. I think that Dr. Gori has given a very good slide, provided a very good slide setting out the main elements. It's setting out the framework for dealing with coordination between businesses designed to cope with significant changes in supply and demand patterns arising out of COVID-19. And this coordination is to ensure the continued supply and fair distribution of products, and we're talking about medical and healthcare products and essential commodities. Printing paper, for example, is not an essential commodity. So we can have a big argument about what is an essential commodity, but it's clear that the essentials are designed to be covered. And services such as logistics and testing. And we're talking, as Dr. Gori has said, on sharing data on stock levels, timings of operation, sharing of distribution network and infrastructure, transport, research, development, and production. Now, what the CCI is saying is that the Competition Act already has safeguards to protect businesses from sanctions for certain coordinated conduct where it results in increasing efficiencies. And what are these two safeguards? And really, we are constrained by what is in the Act, and the CCI is very focused on what it thinks it can and cannot do within the Act. So safeguard one, the proviso stating that the presumption of an appreciable adverse effect on competition applying to competitor collusion does not apply to efficiency enhancing joint ventures. I'll come to what that means in a minute. Second, the positive factors to be taken into account in determining whether there is an AAEC, an appreciable adverse effect on competition, which are stated in Section 19(3) of the Competition Act. And these are accrual of benefits to consumers, improvements in production, distribution of goods or provision of services, and promotion of technical, scientific, and economic development. Now, I'm sorry to cite law at you. It's rather boring to do this in such a seminar, but that's enough of it. And to benefit from these two safeguards, the CCI has said the arrangements must result in increasing efficiencies. But only such conduct of businesses which is necessary and proportionate to address concerns arising from COVID-19 will be considered. That's all it says. And I'll comment on that in a minute in the context of what other agencies are doing. So just a few comments. First, it's clear that the CCI is not giving competitors who wish to coordinate a pass. There's no exemption from the competition rules. The advisory is really saying how the CCI will look at cases where they come before it, and specifically how it would look at the question of an AAEC at the effect on competition. Now, there are differences in the treatment as regards the question of an AAEC of various types of arrangement. So you have to look quite carefully at what type of coordination is being envisaged, what it would involve. You've got efficiency enhancing joint ventures which engage in a type of activity caught by Section 3(3), which is price fixing, limitation reduction, bid rigging, allocation to markets, and so forth. And where they are efficiency enhancing joint ventures, they're not subject to the presumption of an AAEC, but this CCI can find an AAEC notwithstanding that. It's only a presumption. Then there's coordination between competitors not taking the form of a joint venture engaging in Section 3(3) activities. And I take it that some meaning is attached to the term joint venture. That's not defined. These will be subject to the presumption of an AEC. And a third category are joint ventures and other forms of coordination which do not engage in Section 3(3) activities, price fixing the like, but may nonetheless be caught by the Section 3(1) prohibition, and where an AEC has to be established by the CCI. In conducting its enforcement mission, the CCI and the DG might have to take a different tack depending on the nature of the coordination. Next comment, the existence of the presumption of an AEC is clearly a helpful weapon in the CCI's armory. Once it finds collusion of a type covered by Section 3(3), like price fixing, breach is established unless the parties can, usually with difficulty, rebut the presumption. So the efficiency enhancing joint venture proviso is helpful to an important, if limited extent. It disapplies the presumption of an AEC. If it's available, use it. I personally favor an expansive interpretation of joint venture. To a degree, all competitor cooperation is joint and a venture, but the position is not clear. And remember, this is not a get out of jail card. This is the real added value in the advisory, that the activity must be necessary and proportionate to address COVID-19 concerns. That's really what's new. There's not very much else that we didn't already know. And even then we probably knew that, but we needed the Competition Commission of India to say so. To flesh it out, it's not stated in terms of the guidance, but competitors who want to coordinate must act transparently. They can't act covertly. They must be able to demonstrate efficiencies if asked to do so, and must show that the cooperation envisaged is the least restrictive least restrictive competition. This is not a slam dunk, even in the age of COVID-19. Now, it may be helpful to look at the position taken by the European Commission. I do this with some trepidation because I don't take the view of what happens in the EU or the US is necessarily valid in the Indian context. So don't think I'm coming here bearing gifts from Greece or something like that. I'm just saying what happens in the EU. There are long-standing general guidelines on horizontal cooperation which set out in some detail the European Commission's thinking on competitor collaboration. Now, using these long-standing guidelines as a stepping stone, the European Commission has introduced a temporary framework setting out the criteria it would apply in assessing cooperation in a COVID-19 context. You'll be relieved to hear I'm not going to go into detail here, but suffice it to say that it has reintroduced the concept of a comfort letter and has given comfort already to an outfit called Medicines for Europe, who are trying to assure the fair and sufficient supply of critical medicines in Europe in the crisis. And it will provide informal guidance using a dedicated mailbox. Now, the situation in the US isn't much different from this. In contrast, the CCI has not issued general guidelines on horizontal cooperation, which may reflect the fact that there have been relatively few cases. There have been a few cases and a few hints, but nothing very concrete has come out of the CCI orders to date. There's been a couple of cases about efficiency enhancing joint ventures, but even these are not very informative. So it's perhaps unsurprising the advisory doesn't really say very much. But I think that I tend to agree with Dr. Gore's view that the detail would have to be fleshed out in practice. You'd need to have more detailed guidelines on the modalities of collaboration, if any sense is to be made of this, if it's to be useful as a long-term measure, hopefully not too long-term, in the context of lockout. So to go to enforcing competition law, in common with other jurisdictions, the CCI makes it plain that businesses should not take advantage of COVID-19 to contravene the Act. It is open to the central government to exempt classes of enterprise from the application of the Act or to issue general policy directions if there were suggestions that it should do so. I'm not going to comment on that here. That's a question to government and whether people are going to approach government to try and carve out exceptions for industries or types of behavior. But in the absence of such directions or exemptions, the CCI can be expected to act against cartel activity by competitors facing tough times as a result of COVID. It can be expected to act strongly in relation to vertical agreements such as resale price maintenance, provided there is an appreciable adverse effect on competition, which isn't so easy to establish. And it can be expected to act against abuses of a dominant position. COVID-19 excuses will not be accepted. The main elements of enforcement are unlikely to change. So this means that enterprises and their people will need to focus on compliance to check the natural and perhaps increasing temptation to breach competition rules. Just 2 points here. I assume you know something about the modalities compliance already, but two particular risks I think need to be highlighted. First of all, employees working from home might pose increased risks. A lot of people working from home, hopefully nobody I'm responsible for, seem to think they can go on their own missions and adopt their own rules, especially where rules on communication are not very well established. And secondly, trade associations will need to be alert, particularly where you've got relatively small enterprises involved in this coordination, associations have to be careful to behave and to make sure that competition rules are observed. But I was struck by Dr. Gore's comments, not surprised, because I've heard them many a time before, that there are many opportunities in the Act to do all sorts of strange and wonderful things. All the same, remember that the CCI is limited by what is in the Act. Abuse, for example, will not be sanctioned in the absence of dominance. And tough commercial behavior isn't necessarily abusive. In relation to merger control, the CCI is bound to respect jurisdictional limits. It can't reinvent them. It can't suddenly reintroduce a system to replace the certainty that merger processes give with the uncertainty that might be posed if you introduce a system of later review. Now, I'm not going to say anything about merger review, because I'm confident that Satvik will say what needs to be said, and Rajshekar as well. I want to say a bit about towards a new competition normal. I hate the phrase a new normal. I think even before COVID came, the normal was changing. We have artificial intelligence. We have changes in the way the office is working. COVID has shown us that virtual communication works. Who thought for 2 months ago I'd be delivering this training via Zoom, which, by the way, is subject to a challenge in the Indian courts, because I think all the Chinese are going to find out about what we're saying today. And I have no problem with that. Now, it's useful to remind us that life as we knew it a few months ago may not be the same in a few months' time. But not everything need change beyond recognition. And I'd like to quote from the COVID-19 statement taken by the International Competition Network. Maintaining competition in the long term is critical to benefit consumers, the functioning of markets, and our economies. As during our past economic crises, competition agency enforcement and policy efforts to promote and protect competition will be vital to manage the impacts of the crisis and create the best environment for economic recovery. And to conclude, and picking up a point that Dr. Gore, I think, has made, to help to make the worst of times the best of times for competition law and policy will depend. I've been reading a lot of Dickens in lockdown, as you probably gathered. For competition law and policy will depend on sustained action by the CCI and other stakeholders. I would urge greater transparency in the CCI's thinking and the increased use of guidance, whether in relation to coordination or use of green channel or how you deal with platforms, to help steer us to the new competition normal. So thank you for giving me the time. Thank you to Anand, to ABC, and to my fellow panelists for giving me the opportunity to express my views. Thank you.
Thank you, John. We indeed are looking at perhaps a new interpretation, or at least an expansive one, of joint ventures that we haven't seen yet in competition jurisprudence in India, at least before. And it's right to say it's not a get out of jail card, but nonetheless, survival cartels and crisis cartels may nonetheless want to assert that had it not been for the ability to cooperate, perhaps their entire industry or their market would just collapse. So that's something that perhaps the CCI would face with in the times to come. We're running short of time, so we'll take one question amongst the amongst those put in the chat box. Amiya Upadhyay asks, what are the panelists' views on the recent Jio-Facebook deal, and how is the enterprise's big data and network effect is going to affect other companies in this pandemic? Could we have Dr. Gauri and Satvik perhaps answer this, look at this? Dr. Gauri, your mic may be muted right now. Could you please unmute the mic?
Now, why doesn't Satvik start? What's the question properly? Can you state it?
The question is, what are the panelists' view on the recent Jio-Facebook deal, and how is the enterprise's big data and network effects going to affect other companies during this pandemic? Satvik?
I think I'll let Satvik answer, because there's also, one has to think of the Reliance Jio thing in terms of the press note of DIPP. You know, it's not just purely a case of a competition issue that is coming up, but there's also the case, if you remember, of the DIPP noting. And let Satvik first answer, then I'll add on to it if it's required. Can't hear.
Audio is not coming through. Perhaps the microphone has been disconnected.
Not coming through. Can you hear me?
Yes,
Yeah.
now we can.
Right. All right. I don't really want to comment on the deal itself. It's sort of live, and I don't have. I haven't sort of studied it in grave detail. But what I can do is talk a little bit about how the issue of data sharing and data in general, big data in general, is or should be viewed in a sort of deal like this. And starting out from the early days where suddenly big data burst onto the scene, we've sort of moved on in academic circles as well as practitioner circles. Now, mostly people understand that data is essentially a resource. It's not a resource like oil because it's not finite and it's not sort of exclusive. So if one person uses a certain barrel of oil, then another company can't use that same barrel of oil. So, but in essence, it is a resource. Nobody makes money off data per se. They use data to sharpen their, to produce other products that people will buy. So Facebook or Jio will use data to process to figure out who to show what advertisements to and better their targeted advertisement products, which then people pay for. Show these products to their target audiences. And in that respect, what you really need to look at it is in a paradigm which exists in competition law. Does the deal offer control over sort of essential, and are others excluded from usage of that same resource? And there, the difference with a normal sort of foreclosure type analysis is that data is a very different kind of resource in that it's easily reproducible. So Facebook and Google might not talk to each other, but they do have the pretty similar data about you and your preferences, and can tell you the same things about your target audience. So Facebook and Google both have great search algorithms based on their data. So that becomes something that you need to factor into this foreclosure type analysis. So I think I'll stop there and let Dr. Gauri talk on a slightly wider thing, and maybe if she has something to say on the deal itself.
I think I have to, I'm not muted. Can you hear me? Yeah, you know, this question that has come up with data, because we're no longer dealing with price abuses, but also trying to look at data abuses. Things have not been very clear, even looking at the literature elsewhere. And I know perhaps someone like John, who has looked at other countries more carefully, will be able to interpret it. Let me try and put into this context of what you raised, Satvik, that it is not non-rival and it is non-exclusive. You know, this is a sort of problem that you find with patents which go through standard essential patents. So what do you do with them? They're patents, but they're non-rival and non-exclusive. So they can always be used. So when I keep looking at it, and I have looked at even the Google data that comes up, you know, and whether this amount of collection of data will really help them to get into an understanding of consumer preferences. You see, as an economist, a lot of data is white noise. And to be able to understand consumer preferences and to change a fashion, you need a very specific random sampling to be able to decide it. So I have not been able to get as much a concern as possible on data. But what's interesting is whether this data itself gets sold. You know, you're creating another market of data, of selling of data, which is very close to what the standard essential patent, Ericsson or who's the other one, Qualcomm, are doing. They're pooling it together and selling it. And here I find it's very important because I keep thinking to myself on the Monsanto case. What does Monsanto case want? Newsweek files the case, but Monsanto wants to know data at the ground level. Can't we create a farmer aggregator? Data gets pooled in and sold. There are different ways in which this whole thing can be handled. And then the data, this privacy issue, we have not yet done the privacy part of it. Would I like data which is not anonymized and used, because India has every disease possible, so it makes you uncomfortable. And lastly, and very quickly, a thing that bothers me is the cartels of algorithms. This is the case when you have airlines. Sure, there's a cartel there somewhere. I've not been able to pin it. And this is all I have to say without making a very, I can't, this is not something that you can make a definite judgment. This is a growing area.
Thank you, Dr. Gauri. So in the context of what's already also been spoken about data and big data and essentially also delineating markets, etc. It is also perhaps, or I can put it this way, whilst it's not the only or the most relevant factor, and especially in the context of Google, I suppose this comes into relevance. Market share is commonly taken or mistaken as an indicator of market power. Now, the lockdown has made market shares a largely meaningless concept in the context of at least some of the sectors which have been completely shut. So for this period, you can look at aviation or hospitality, automobiles, for instance. One can say that perhaps they have no market power or market share if you just look at it in a layman's traditional sort of way. And can you really take patterns of market power that existed perhaps up till 2019? They may not have any meaningful ex ante future-looking value. So I would invite Satwik to talk about how the commonly used analytical tools and methods will need a relook, among other things.
Thanks, Anand. And let me just sort of echo first what John had said, that it's very difficult to speak after Dr. Gauri. Of course, I am now speaking after both Dr. Gauri and John, two sort of stalwarts, and so you can imagine how difficult my job is. Thank you for having me. Thank you, EBC. My plan is, what I'll do is I'll try and focus more on the aspect of how competition practice, how the practice of competition law will change from the perspective of the legal profession, economists, and the regulators. As John said, there will be a fair amount of crystal ball gazing. Us economists, that's one of our main selling points. We tend to think that we crystal ball gaze better than people in other professions due to some mathematical and statistical jugglery. So there'll be a fair bit of that. So the plan is in macroeconomic terms, what a pandemic means for individual markets, what the current state means for certain commonly carried out competition analyses, and then I'm going to go into very briefly the trends that I expect to see in competition law analysis in the short, medium, and long run, highlighting the sorts of analyses which I think are going to become more important, and the analyses and the tools which I feel are going to be less relevant going forward. So, starting off, what does a pandemic like this do? What does an external shock like this do to the economy or to an industry? Well, viewed very simply in macroeconomic terms, what you have is a contraction in both demand of products and a supply of products, right? There is a contraction in demand generally in the economy because people are staying put at home. They're not allowed to go out. They're not allowed to buy things. And then there's a shortfall in supply because there's a shortage of labor, factories are closed, people are sequestered at home. And so you have, if you sort of look at it in terms of the old Marshallian cross, the supply-demand curve, you've got supply and demand both sort of shifting down, and it's sort of, that's where we are. Now, There are three important nuances here, though, right? The first one is that the decreases in demand and supply have been uneven across industries. So the industry, for instance, industries related to healthcare products, sanitizers, masks, ventilators, etc., you've actually had an increase of demand, but a decrease in supply. The second important nuance is that a lot of economic research, particularly in the last 50, 70 years, has shown us that industries, firms, and the economy takes time to adjust to an external shock. You don't simply move from one equilibrium to another equilibrium immediately. You have to make decisions about how you, restructure your factories, about how you restructure your labor force, your mix of products. You have to put things in place. It takes time for adjustments to happen. And the third thing, and then on top of that, we have a situation here where it's not that we know what the world is going to look like, because we still have a massive amount of uncertainty about how this whole thing is going to end. So even the sort of long-term goal for companies is constantly evolving. And then on top of that, the third nuance is that recent research, 20 or so years, has shown us that people don't really act in a rational fashion a lot of the time. Economists and most economic models, therefore, are based on this notion of rationality, of the idea that governments, people, firms try and maximize things like profits or consumer welfare and things like that. But we know from actual research that that isn't always the case. There's reason to believe that people are behaving even more irrationally right now, because there is no sort of scholarly research body which there is no body of research which says that this is the correct or the rational thing to do in this set of time. So we're dealing with a lot of irrationality as well, which will further delay the process of sort of going back to responding to the shock and adjusting. And as a result of all of this, what you have is you have now a state of disequilibrium. Now, why is that important? The fact that we are now mostly in disequilibrium means that the basic economic framework that you use to analyze the economy or individual markets has to change. Because economists and competition economists in particular are very fond of using static models, like your demand supply framework. A static model is a model where you have two countervailing forces and they interact, and you can say, okay, that's where the equilibrium is. So the equilibrium price is that and the equilibrium quantity is that. These are simple, they're tractable, they're very easy to put numbers into. And so a lot of antitrust concepts come out of static models. What you need, however, static models don't tell you anything about how if you are knocked out of that equilibrium, do you get back to it? The is something which static models are completely silent on. And that's kind of what we need right now. So a static model will tell you that, okay, if the demand curve shifts like this, the new equilibrium point shifts over there. It doesn't tell you how we get there. And what we need to know now in the next couple of years, at least until all this is passed, is how are we going to now get to that. So economists have increasingly now developed more complex models which take into account this adjustment process. And these models are already used when it comes to industries of the type that Dr. Gauri was talking about, nascent industries, industry ideas. So if you think about foremarket, aftermarket, that essentially is a dynamic idea. So a lot of this is something that's been around, but will now need to become the standard rather than your usual static framework. So what implications does this have for your normal, usual competition analyses? And a lot of the practitioners in the audience might be interested. How do you think about market definition in a scenario when you're in disequilibrium? Well, the first thing that you need to think about is market definitions probably not going to be the same as earlier. Think about, for instance, when you talk about movies. People wouldn't think twice before putting live action movies and animation movies into the same relevant market earlier on. Now you don't, live action and animation are two very different production processes, one of which is completely stalled because you can't put large numbers of people together and shoot a film. But animation can go ahead because it's a bunch of people sitting separately on their computers and making film. So the competitive constraints between live animation and live action and animation are now relaxed. So are they in the same market anymore for this period? Who knows, right? So precedent, you can't rely on precedent anymore. You have to go back to fundamentals and really look at market definition through qualitative tools, like, for instance, public information that's put out by companies, surveys, or even quantitative tools like price correlations in the period of that you're talking about, estimating elasticities and so on. So it becomes a lot more involved. And then I think the big one is, how do you assess market power, right? Because the idea that market shares might have a relationship with market power is an idea that follows from a purely static framework. In a dynamic framework, when you're off equilibrium, market shares have an even lower relationship with market power. Even things like the learner index is a static equilibrium context. It doesn't apply when you're not in equilibrium. So you have to really go back to fundamentals, right? If you're talking about dominance, say, okay, how do we assess whether there is an ability to act independently of competitors? Are there any barriers to entry? What happens to capacities? Is capacity increasing? Is capacity decreasing? What's happened to the, maybe use a dynamic model to see what you expect the new long run equilibrium to be like, and then see, okay, we're headed in that direction. What's the adjustment process on the path? Does this firm have the ability to act independently? So again, it becomes a lot more complex and a lot more involved, because you don't really have recourse to your simple straightforward market shares or HHI numbers as some sort of indicator of market power. So what happens now, let's turn to the second part, which is what we expect to see over the course of the next few years rolling out. So the really short run right now, we have in an economic crisis, and this has been shown again and again, mergers tend to pretty much disappear or go down to a very low level. So merger activity will slow down. A lot of the cases, especially given this talk about coordination amongst competitors, is going to be about cartels, right? And there's going to be two types. There's going to be those cartels which are necessary to deliver essential services, and there's going to be loss-inducing cartels, loss-reducing cartels, and I think enough has been said on that, and I'm not going to go into that. The other thing that you expect to see in this sort of period is a lot of excessive pricing. There's this uneven effect of this pandemic on various markets. There are some markets for which demand increases and supply decreases, and so you'll have a natural increase in price. Now, it's important to know two things. First is only a subset of those get caught under the competition framework, right? Excessive pricing can only be sanctioned under competition law if there is a dominant firm doing it, right? What do you do when there is essentially, you just have a market where there's reduced supply and increased demand? There may be 100 sellers, but the fact that the demand is shot through the roof means that they can now charge a higher price, all of them acting completely independently, right? And there, obviously, your first port of call is going to be trying figuring out whether there is a dominance. But if there is no dominance, my opinion is that the competition authority shouldn't actually intervene, but the competition authority should work very closely with the government to intimate them that, look, here there is this product where we think that there's a demand supply mismatch. You might want to look at temporary price regulation. You might want to look at putting it under the Essential Commodities Act or things like that. Or if you're dealing with a client who's affected by this, you might, rather than advising them to go to the Competition Commission might want to say that, look, you might want to file a writ petition in the courts to say that this is a problem. Maybe you need to introduce a price cap in this for a short period of time. But if you do get a firm that is dominant, then of course you have to really start applying. And we haven't seen very many excessive prices cases. Yeah, so you have to go down the whole United Brands test. You have to do price cost tests. And again, the problem with price cost tests is that your costs are also constantly evolving. You're readjusting your costs, so you have to take that into account. And then this whole issue of, is the price unfair of itself, an intrinsic value test. And again, the intrinsic value test tries to figure out what the value of the product is to the consumer, which again changes. So you can't use historical data. You have to be a lot more creative. Now, let's turn to the medium run. Once all this is over, the lockdown's up and people have figured out where we're going to look at a return of sort of mergers. But there's going to be two main kinds of mergers that I feel are going to dominate. And the first is institutional investors are going to look for low-hanging fruit. We all know that investors love market downturns because that's where they can enter low and then. So institutional investors are going to try and pick up low-hanging fruit, and B, they're going to try and rejig their portfolio to take into account the new way the economy is going to work after this whole pandemic is over. And because you're going to see this explosion in institutional investment, which is already on the upturn, issues of common ownership are going to become very, very important. Now, as is, we've not been very good at dealing with issues of common ownership in a quantitative way. The way we've dealt with it has mostly been, let's just assume the worst. And if there's no problem, if there's a full merger, then let's just let it through. But of course, that doesn't work most of the time, as I found out on a case that I recently worked on, and which has been passed, but let the order come out and then we can talk about that. So there are tools. For instance, economists have modified the HHI framework and the Guppy framework to take into account common ownership. So the indices are calculated at the level of the individual owners rather than the firms which they might commonly own. And you have to take into account their financial and their ability, the financial stake and their ability to control. But of course, you need to make the adjustments for, because merger control is a forward-looking framework. You need to adjust them for what you feel the new long-run stable equilibrium is going to be, and use those numbers to feed into these things. And then, of course, you're going to have the second big category of mergers, which is the mergers where the firms are going to become stressed and be sold. And so the failing firm defense will become really, really important. Now, I just want to take 1 minute to just focus on the failing firm defense, because in India, we've really only seen failing firm being used in the context of IBC transactions, where bankruptcy has been filed, and of course, there's a certain set of IBC filings which are basically to recover debt, but we're not talking about those cases because those really CCI, like you don't really have an insolvency professional appointed and a committee of creditors and a purchase. So until now, the CCI has seen failing firm defense in the context of where you already know that the firm is going to fail and a buyer's already been identified. Now, we also know now that the government has suspended the IBC for at least a year. So we're going to see a fair few cases where you're going to have stressed assets that are trying to be sold, where we don't have an IBC to tell you that the firm is failing. So you're going to have to do a lot of brass tacks. You're going to have to get down to the brass tacks of doing an actual failing firm defense, which means you're going to have to do all three limbs of a test. Will the firm fail? Which will require you to go down, analyze financials, analyze the way the market is supposed to develop. Will the assets exit the market, leading to a fall in production? Is there any less anti-competitive alternative? So can we find an alternate purchaser, or is it so bad if the firm actually dies? So all of these analyses, which were sort of taken for granted earlier, will now have to be done by the notifying parties and the commission when it assesses this. So this is going to be important, and this is something that we haven't done very much of. And then just to conclude, what's going to happen in the long term? And I think this relates to one of the questions which we didn't address. But there is, you've heard this whole talk about Atmanirbharta, about self-reliance. And a lot of countries are pushing towards self-reliance, because you had this experience where suddenly you need loads of masks and ventilators and you didn't have them because you would import them from China. But when you wanted to import them from China, China was shut down. So there was suddenly a shortage because you didn't have stockpiles at home. And so countries will want to sort of define, again, go back to like we need so many firms producing XYZ products at home. And that is going to clash slightly with competition law, because you might have foreign manufacturers of masks saying that, well, actually we can make things better and more efficiently than you can. But the government will then say, well, actually we need to be self-sufficient. So that's going to be an interesting battle that may actually spill over into the larger legal framework about whether such restrictions are justified, to what extent such restrictions are justified. And I think that's a battle that we fought in the courts. So to sort of just very summarize, I think failing firm is going to become very important. Common ownership is going to become very important. Assessing dominance, market power, and market definition is going to become difficult and much more creative. And excessive pricing cases are going to become very important very immediately, along with, of course, a whole host of cartels which look to reduce losses. I'm sorry, I think I've gone a bit over my allocated time, but yeah, there's a lot to unpack there, and we can talk about it later. Thanks.
Thanks, Satwik. There is generally a lot to unpack in this whole pandemic, and possibly all the fallouts from it and the different sectors. And I think it requires a detailed analysis. However, we are short of time. Perhaps one of the things in connection to the IBC process that the Competition Amendment Bill perhaps addresses usefully, and the CCI, since the Parliament is not in session, the government can consider Section 54, is the proposed Section 6, Clause 7, which says that a standstill obligation may be exempted in certain category of cases, and there will be no penalty under Section 43A. If there is perhaps urgency, and I'm sure there'll be sufficient debate on this as well, but this is something that the government could consider. In all this, the assessment of consumer benefit and harm seems to be pivotal at this period, and for determining whether horizontal or vertical agreement or unilateral conduct or merger would pass muster under the competition law. Another common theme seems to be that even when such insightful, even with the insightful inputs that we've had from our panelists so far, is that uncertainties in the market and its analysis are pervasive as the virus itself. Lots of gray areas. So in this backdrop, I invite Mr. Rao to provide his views on competition enforcement and what lessons perhaps can be learned from elsewhere, if time permits, temporally and spatially as well.
Thank you, Anand. At the outset, thank you to EBC for having us over. And as I think Satwik said, when you have to speak at 1 p.m. and that too after stalwarts such as Dr. Gauri and John and Satwik, who's obviously a great name to reckon with in his own field, it becomes easy and difficult at the same time. Easy because they've covered most of the ground, so I just need to kind of, in a sense, tie in the threads. And difficult because you have to then obviously try to be very, very different to even be relevant. So let me start. So I thought the best way to do this is to start with some humor. We need a lot of it during these times. And I'm going to try and intersperse this brief presentation, which I've found being new to the webinar circuit is something that helps me keep my mind on things and on track, and also kinds of breaks the flow in terms of the monotony. So without any further ado, we all understand that the topic is, of course, competition law, the impact of COVID-19. And I'm asking the question, which I believe is really the question that's in the front of everybody's minds. Pandemonium and the pandemic. Is there going to be pandemonium, or is the CCI and the government of India, do they have the ability to kind of bring some structure to our lives? Now, while I was just looking at this, I went back looking, there's this old adage, and to borrow from P. Sainath, everybody loves a good drought. The way I see it, everybody loves a good crisis too. And when I went to look for the etymological origin of the word crisis, you'll find, it comes from Greek, and it's a turning point in a disease that change which indicates recovery or death. And therefore, and of course, there's a very interesting concept of midlife crisis from Germany, basically saying that you don't want to be on the wrong side of the door. I think every crisis presents an opportunity. It's an opportunity to kind of revisit what you've done so far, and more importantly, to kind of see what are the changes you need to make to perhaps improve the way you've been in the past. Taking a cue from that, since we are talking about competition law and we are governed by a statute, just to remind ourselves, what is the focus of the statute? What did the legislature intend to be the key focus when they enacted the Competition Act in 2002? And please remember, it is a 2002 statute, which took nearly 7 years to see, legal fruition in that sense. So obviously there seemed to be a huge gap in what the lawmakers wanted and what really was on the ground. But the bottom line is this, and there are two key threads that emerge from the preamble. To protect the interest of consumers and to ensure freedom of trade carried on by other participants. So the focus is the interest of the consumer, and the other focus is competition, to preserve and protect competition. So the market participant, really speaking, is in a sense not really the fulcrum or the focus of the act. The Supreme Court kind of looks at the statute, it's the locus classicus in sale, and effectively sets out what are the primary purposes of competition law. I'm not going to read this due to paucity of time, but essentially what it says, and there's a small passage here, they say that competition law, like any other law, has to remain dynamic and has to keep pace with time. And even within a legal structure, the objects of competition law can vary from time to time and jurisdiction to jurisdiction. And that really is the flexibility that gives us, at least gives me as a lawyer, hope that if the authorities that be, and particularly the CCI and the Government of India, look at the Act as a tool of empowerment and not something, the way a teacher sees a stick. If you look at it as a carrot and, in a sense, being somewhat like the wind beneath the industry's wings, I think it would be much smoother sailing insofar as COVID is concerned. Takes me back to the point that Dr. Gauri raised, was the advisory necessary? I mean, does the advisory say something particularly new? We all understand that it doesn't. I mean, it's stating what the Act says in a sense, and says, but it's important for that conversation to happen because it tells you that the CCI is there. The CCI is there to assist. The CCI is there, more importantly, to watch. And at the same time, and it's a timely reminder to everybody that, be that as it may, the Competition Act is still active, applicable, and will be applied if necessary. And I'm going to just get into that little bit because at the end of the day, that's really what the Competition Commission was set up for. And those are the duties of the Commission. The Commission has an object, again, to preserve competition and to protect the consumer. And more importantly, it has a variety of tools at its disposal to do this. Now, I don't think any of us, when we were celebrating New Year's Eve on the 31st of December, really thought that 2020 will turn out the way it did. And there are these, several memes that say perhaps 2020 needs a reboot because there's a virus out there. In that context, it's good to look at historical reactions to various crises, and we've had a fair number of them over the last century or so. And given that, say, antitrust legislation started seeing the light of day in the late 1890s, or rather 1890s, when the Sherman Act was enacted, and you see a fair bit of antitrust activity in the United States and subsequently in the European Union in the 50s. I thought it might be useful to just get a sense of how, what has been the reaction of the authorities in circumstances like this, and did it really make a difference to the market? And does the CCI have the ability to derive some sort of lessons from there? I think what I did find when I looked at it was there seems to be a slight shift in the approach as far as the United States is concerned in World War I versus World War II. World War I, remember, was Woodrow Wilson. World War II was FDR, and there was the New Deal and subsequent. World War I seems to be a situation where the government took a policy decision that we would rather err on the side of keeping antitrust actions, enforcement actions on the side. And as long as you were participating in a manner which was conducive to the national interest, we'll look the other way, or rather we will actively participate and help you do things as long as there was the overall national objective was met. This is a really interesting article which kind of gives you a brief idea of how the US wartime response was. And please see the difference. The difference is insofar as World War II is concerned, there is heightened legislative activity between World War I and World War II, and you have the Clayton Act, etc., that comes into play. And FDR decides that we will, of course, continue to maintain enforcement actions. And as you'll see from the slide in front of you, that two of the highest profile, section antitrust jurisprudence during World War II were prosecuted during that particular time. Having said that, again, it was largely a policy issue. They kind of looked the other way in certain instances, but I guess the point was that antitrust legislation was there to stay, and enforcement, more importantly, was there to stay. We have a few cases which give you an indication of how the United States responded. And Fosberg is an interesting case where the circuit court, the Ninth Circuit Court, effectively looks at a situation where people come together and enter into an agreement which in the ordinary course one could contend was perhaps anti-competitive. But, they were in a sense led off primarily because, and see the timeline, it's 1923. And the court seems to suggest that, so while it was true that free competition as it respects the sugar commodity in the market was somewhat interfered with, then concludes to say, at the end of the day, find the justification. And that's why I said it's ultimately upon the regulator's approach to how it wants to enforce the act. So this was a case where the regulator finds that, yes, perhaps, I mean, the court finds that, yes, perhaps in the ordinary course, you could say that this was per se bad. But having said that, they conclude, surely it was not the intent or purpose of the contracting parties, thus to impinge upon the element of competition or interfere with the regular course of trade. They, together with the Food Administration, were acting under a dire necessity. And I shudder to think whether this defense would fly in today's times. But this is the historical, this is history, and much to learn from it. Imposed upon the community by a state of war, and the community in the interests of humanity would be adequately supplied only through the method adopted or some other having a purpose, a like purpose in view. And the court decides to look the other way and effectively says, no, we'll remand the matter back. And the court concludes that it was not satisfied. I mean, it's not satisfied. Another instance is the Appalachian Coals case, which again was a coal cartel, and the court seems to think that because it was on the cusp of new technology, the coal industry was soon being replaced by other forms of energy, and perhaps would no longer be relevant in the overall scheme of things, or at least had enough competitive constraints on the ground. The court, the US Supreme Court looks, essentially says, we will not proceed, but at the same time leaves it open to the authorities to prosecute any other anti-competitive conduct that may ultimately arise. And that you'll see from the last paragraph. Just moving straight on again in terms of, so this is, you have the World War, and then of course you have a series of economic, silence in that sense. Till you have 9/11, you have the 2008, as Anand says, it was the Great Depression, the Great Recession is what it's called. And of course, now you have COVID-19. Now, what's interesting is, I think World War I versus World War II. World War II, the Great Depression continued over a period of time. And that's one thing that I would perhaps, look to Satvik for some guidance on. But how long does a situation have to remain alive for it, from a competitive law, from a competition law perspective, for it to be seen as something that really skews market conditions? Is 1 month of no production, no sale, is that enough? Or does it have to be necessarily of a longer duration? And which is why, contrast the New Deal, the Great Depression, which went on for nearly about 10, 15 years, versus say the effects of 2008. I think it was in 2 years, you could see US markets rebound. A large chunk of at least the US economy had bounced back. And you saw some rippling effects world over, but not really something that continued for too long. We have the pandemic, and strictly speaking, if you look at India, the pandemic has perhaps hit us hard in the last 2-3 months. Now, is a 3-month window enough? Is that sufficient? Or is that something where a regulator could just look at people and say, that's a blip in the universe. Frankly, I cannot condone any kind of behavior. You get no special treatment. Or ultimately, do you look at the impact of that activity? And we are in a stage where attention spans are short, developments are happening much faster, timelines are obviously getting shortened. And in these circumstances, also given the fact that we see an increasing number of large enterprises not having the ability to sustain themselves or their operations unless they are in a 24/7, 365-day work cycle. And that's the scary thought, at least from an outsider's perspective, that are these big corporations which are really huge and have multinational interests, are they such that they cannot really sustain themselves for more than 3 months at a time in the event that they are required to do no work, and can they not take care of their people? Ties into a very, it's the tricky area of labor laws, etc. I think that's good for a webinar by itself. But similarly, so the EU, I think what has happened between the World War and say today is tools have become sophisticated, regulators have become a lot more active and proactive, and have found various ways to set out not only various tools, not only to investigate and to catch, but also to set out guidelines whereby they have, in a sense, catered to a whole series of eventualities, including this. And the advisories that one sees being issued by competition regulators world over, some a lot more detailed, some very specific, some very broad, are all indications that competition regulators are taking a view one way or the other, and are actively involved. Just flagging the Irish beef case from the EU perspective and contrast that with the Appalachian coal case. The US court seemed to take a view that we look the other way in the larger scheme of things, of course, with reference to the fact that it was not really creating an impact on competition. The EU took a slightly more stringent view in the Irish beef case, because this was a case where some of the biggest players, and if I'm not wrong, they were about 10 of manufacturers of beef or producers of beef, decided to get together to say, we will now consolidate the market in our hands, and people who leave the market will be compensated. And the commission took a view that it was really anti-competitive and didn't condone behavior like this. Now, all of this ties me, and I know I'm running, but I realize that I don't want to come between you and your lunch. And I know we'll have some questions to be taken. That's the worst place to be in. This is one of my favorite judgments. Shiv Shakti Sugars is Justice Sikri's decision. In a sense, it states the obvious, but I think it puts it out at a time when it could not have been more relevant. Effectively, Shiv Shakti Sugars essentially says you have to look at the economic impact of your decisions. And while this is, of course, addressed to courts, it's equally important to every sector, including government and, more importantly, the CCI. Interestingly, the Supreme Court also notes that the Competition Act has at its foundations the interplay between law and economics, and which is why, of course, one hopes that the gap of a member law will soon be filled. There is some amount of uncertainty there. So I've always believed as a lawyer, and particularly as a litigator who appears there, that it's useful to have somebody who brings some amount of legal expertise in terms of the approach that one follows. The reason I flagged this is because, really speaking, it ties into the concluding part of what I want to say, and I'll take a few minutes here. What are the ways forward as far as the CCI is concerned and competition law per se? When John made a reference to Dickens, I quickly changed the title of my slide, and so it's a tale of two CCIs, and the way I see it, it's a CCI pre and a CCI post pandemic. And these are my, I think these are my expectations as a lawyer, and I guess this is my wish list. And I'm trying to be as neutral as possible, not as somebody who wants to get relief from the CCI, but just wants a regulator that truly discharges the duty that it was envisaged to do under the Act. And most importantly, to find that balance which enables it to really step in where the need is imminent, while at the same time, and of course, do the whole, high-handed 27 imposed penalties, go the whole shebang, versus does the CCI have the ability, notwithstanding the 26(1) framework, because of its duties under 18, to also start engaging with industry and stakeholders in a more meaningful way? Is it possible for the CCI to consider, particularly in these times, and then use this as a means to move forward, to say, we'll pick up the phone, call people who we believe are probably, hanging on the cusp of violations or are in the process of violating, and have a frank chat with them and say, listen, we know this is what you're up to. We believe you're on that thin, you're walking a tightrope here. And where, really speaking, and because, and tying back to the preamble, the object is the interest of a consumer, where the CCI knows that while, yes, these arrangements, which seemingly are anti-competitive, may result in the enterprise making, or the enterprise or the enterprises perhaps profiting a little, if it makes no real difference to the ultimate consumer, are these cases that the CCI should be willing to step back and say, I've put the enterprise to notice that I'm watching, but I will not enforce the act. And I'm just taking a cue from, and again, by means of disclosure, this is a matter that I've appeared in. It's the batteries cartel. And strangely, there were two informations where leniency applications came forth. And, somebody said we were engaged in a cartel involving the sale of batteries. Now, we all understand that the entire battery market has changed dramatically. And, while we grew up with batteries being a complete necessity, today you probably buy 6 batteries in a year. And, the total spend on batteries per household perhaps probably doesn't even exceed 100 rupees. Now, yes, if you multiply that into the number of batteries sold versus the profit that an enterprise makes, perhaps it does add up to a substantial number. It could run into a couple of 100 crores, maybe a little more. But in an economy where we are looking at, Prime Minister is talking about a $5 trillion economy, do a couple of 100 crores matter? Does the CCI really want to waste its time looking at, what I believe are, in a sense, it's equivalent to penny stock? And should the CCI therefore simply look the other way and start gearing itself to look at the bigger challenges that come, that we are, bound to see happen? That, as Dr. Gauri says, big data, pharma, standard essential patents. And these are things that impact many lives in many ways, have a huge economic and perhaps other ramifications. And those are the things that I believe that the CCI should be doing. Tools with the CCI, 21 and 21A, nothing stops the CCI from reaching out. Let sectoral regulators start, playing, assist sectoral regulators, use your resources to assist them rather to try and prosecute, because there is a cost to prosecution. And given the dismal recovery rate that the CCI has seen, and I understand it's not so much also from the CCI's perspective, but it's also because of the skewed appellate procedure that we have and the delays that take place there. Is it really the role of a regulator that was envisaged under the Act? That's one. Number two, very practically, and this is my reach out to the Commission, please let us carry iPads and computers to hearings now. I understand there are concerns, but printing, there's an ecological impact. There is a health impact. The less number of bags, the less touchy, feely. And more importantly, I think it makes life a lot easier for all of us. We are moving to a new platform. The CCI has to learn to kind of allow us to work with those. And in fact, should be at the forefront of leading that, particularly now that it's moved into its fancy new digs. Like I said, choose your battles wisely. That's the same point, and I don't want to repeat myself. And I think it's very, very important for the CCI to be seen as engaging very periodically with the market and stakeholders. This is not about doing reports and market surveys. This is about actually getting people into a room and having conversations. It helps a lot of the air to be cleared. It allows parties to get a sense of where the CCI is headed. A lot of this informal discussion leads, in my opinion, to better practices on the ground and more compliance. Really speaking, who's the person who should be stepping up the most here is, according to me, the central government, because that's the easiest defense in an antitrust case, that I'm in fact discharging, what the law envisaged. And if the central government begins to use its powers under 54 to exempt or 55 to issue directions, that would go a long way in enabling parties to get some clarity. Now that I said there must be some humor, some humor, is something I tried yesterday. So the CCI and antitrust, of course, are synonymous, but I'm just wondering whether the CCI in the course of its conversations needs to start saying trust me instead of antitrust me. The other thing, of course, is Go Corona Go. That seems to be the anthem of the season. But more importantly, I would think this is the best opportunity that the CCI has got to kind of revisit its entire jurisprudence of the last 10 odd years, and to perhaps lay the groundwork for the next 30 years. There's a lot been said about Atmanirbhar and we want to be here, and et cetera. If the competition regulator is really not on board in real terms, that is a great fetter, because you have to be, like I said, the wind beneath. final thoughts. This is, one of my favorite books. Somebody gave it to me a long time ago. I mean, told me about it. I managed to pick it up after my children turned 13, and I wish I had it earlier. But looking at it as one large family, and the CCI being, in a sense, a parent's patria, this is just one passage from the parents' Tao Te Ching. If you want your children to follow along a certain path, you must lead the way the ocean leads the river home by remaining below it. And that's the point I'm making. Post-COVID, perhaps the CCI should just, in a sense, be under, uplift the industry, be there, correct them where needed, correct them softly where needed, and more importantly, at the end of the day, try and encourage best practices. That's perhaps the only way I see, this being a positive outcome rather than a pandemonium. And therefore, in conclusion, I'm happy to take questions later. Have a good day and a pandemic of a weekend.
Thank you, sir. I believe we are unfortunately running into a period where I think the hunger for food perhaps outweighs greatly the hunger for knowledge. So we'll keep our questions again. We are getting a few questions as it goes, but we'll try to keep them, keep a couple of questions only. I think 2 questions we've received about should the CCI temporarily allow collaborations among market players and the applicability of Section 54. I think Raj sir's comments have hinted at that perhaps that is something that can be used as a tool, but largely that remains something perhaps that the government needs to do and not the CCI itself, because those are powers of the central government. I'll go to another question again, which takes it back to perhaps assessing dominance and whether especially in this period. Rahul Jain asks that can the ownership of huge data sets by entities be used as an indicator for dominance for the purpose of perhaps looking at abuse of dominance? Now, again, while this is not entirely perhaps relevant in the context of supply chain disruptions, etc., but would John and Satvik want to weigh in on this? John, I believe your audio is muted. Perhaps, John, you could try to disconnect the device and then speak directly using the microphone of the device itself. We're still not getting an input. Perhaps Satvik can go to you to have a look at this, and we can come back to John perhaps after that. No audio. Satvik, your seems to be some technical glitch here.
Perhaps Andy,
you hear me now?
take it. Yeah, I think we could hear somebody right now. Yeah.
No, I'm not hearing anybody.
Yes, John,
John,
we can hear you now. John, do you want to answer that? We can hear you now.
Can you hear me now?
Yes.
Okay. Sorry, I don't know what's happened there. I think it's an outside system, not my problem. I don't want to say, sorry, the question is in relation to the possession of data, right?
Yes.
I don't want to say too much of fear, maybe used against me in some later life, but I think it's fair in the question of dominance by implication that in today's world, if you're looking at the size and resources of the enterprise, the economic power of the enterprise, these factors must be relevant. That's all I really want to say. I don't want to go into a lot of detail, and I'm not sure if I can without thinking more about it, but I think that the value, and we were talking about market share and market power earlier, market share is not all there is to dominance. There's a lot of other factors, and I suspect that we are going to be looking more at those other factors in the future when market share data becomes a little more risky. But sure, if you're possessing a huge amount of data or a huge amount of iron ore or whatever you may possess, that's going to have some indicative value in terms of dominance and or market power.
Thank you. And there's another question perhaps that relates to enforcement and how the CCI could possibly look at it, is the imposition of penalties. Now, should the CCI be, how should the CCI perhaps go about imposing penalties for conduct that has taken place during this period? Considering, for instance, the case that Mr. Rao referred to, Shiv Shakti Sugars, if the effect of the imposition of penalty puts the industry as a whole on a further strain, should be a relevant consideration or not? Or should it be that things that you were warned about not to do and you still went there and did it, there should be harsher penalties? So can I just ask perhaps Dr. Geeta Gauri to weigh in on how penalties or remedies would be looked or should be looked at by the CCI during this period?
I was thinking about the penalties last night, and I think under these circumstances, when CCI has given an extra mile, they have to be harsh. And these are difficult times. And if someone is trying to use a market situation for self-gain, not so much even, I'm not even bothered about the competition law, but I do have a moral obligation to think in terms of the whole economy, in terms of the world economy. The penalty has to be very high. And if that's why I said, I think in my speech also, that even if CCI had not given these advisories or allowed for more investment to come in, they can have a much more higher penalty. That's my view.
Ms. Raj sir, would you have any views on this, since you gave an interesting perspective on perhaps go CCI, go, etc.?
Okay, so I look at it as a practitioner, and I'm completely at sync with what Dr. Gauri says, that yes, it's important to use the stick where it's needed. But I'm just wondering, and that's the balance. I think that's the critical balance. At the end of the day, if it's an industry or an enterprise which serves a function in society and is one of the few, the fact that it's made money immediately, does that mean that the CCI imposes a penalty that effectively prevents it from continuing with its day-to-day working? Or does the CCI have the ability to tailor its penalty in a manner where it is recovered over a period of time? So you give the enterprise the benefit of using the money that it has earned for the interim, but perhaps with the understanding that you will recover it when things get slightly normal. In another case, perhaps notwithstanding the fact that the enterprise did make money, if there is a justification, I mean, somewhat like akin to being a failing firm, and therefore you effectively cartelize to essentially survive, and it's the very essence. And the penalty effectively tips you over and makes you go under. That has a consequential impact on employees, other contracts, other industries which are dependent or associated. That economic analysis, I believe, really must come into CCI's penalty assessment, which at least I don't think I see very often. It's a very crisp, translation of 27 and saying percentage number, turnover, etc. Perhaps I would want to see a lot more of that, and that pushes us as lawyers also then to up our game in terms of justify conduct, and more importantly, be able to argue proportionality.
Can I just add one thing? That what you're saying is very right, but I should have said it earlier, that before a penalty is levied in the commission, there's a lot of discussion that takes place, percentage. How will it affect the economy? Even without a post-COVID state, in the cement case system, how much should be levied? If you levy too high a thing. So it's, I'm saying is, there are two things. That these are discussions that take place within the commission. The commission is equally bothered about the outcomes. And the second thing that is very, very important is that if there is an act and a law, then I'm sure as a lawyer you will agree that people must understand to respect the law.
Absolutely. Absolutely.
Thank you, Dr. Gauri.
Could
Yes.
I weigh in very quickly here? This is very confrontational, very controversial. XL crop care, the Supreme Court had a lot to say about this, and it's a good basis for future thinking. I'm sure the CCI should be thinking these things. I'm glad it does. It's not punitive. You're not designed to put a business out of operation. I think that's good. I think that the one thing that should happen now is let's have some guidelines. This is a good opportunity to have these guidelines that the Supreme Court asked for, or Compat asked for, I can't remember which, but we don't yet have. This is the time to get the guidelines.
Right, and can I also just very briefly say that the guidelines are important not just to sort of streamline the processes. It's also important to have the correct guidelines to disincentivize bad behavior in the first place. Because currently you have a situation where, because you don't have a streamlined process, you sort of feel that, okay, if I get the proper representation and I pull the correct strings, I can get away with a little bit of it. So, you know, in the sort of grand calculation, I can, it's business costs. I'll do it, and I'll do my infringing behavior anyway. So the guidelines which make things transparent and in a sense more automatic also behave as a good disincentive for companies to not engage in this sort of behavior in the first place. So I think, you know, COVID or no COVID, the punishment should be proportional to the crime, and there should be an established way of calculating that proportion and the value of that crime.
So just closing the loop on all of that, I think what we all seem to agree is that generally competition principles can be applied to the to this situation and what may follow after, but may require some tweaks and actually the brass nails and tacks that you may need to get into the specifics of it and how to actually apply it to certain markets and in context of mergers, etc. And also that perhaps guidelines in all these respects, we may not need to copy it per se from the European Commission, etc. We can apply it to our own understanding and our priorities as a government about what kind of economic policies we need. But the guidelines actually prove a very important lodestar in understanding perhaps on what generally is allowed conduct and what is not. And perhaps the language or one mistake that lawyers often make is that they look at the statute in a very black and white terms, and it's essentially an economic regulation. So perhaps greater guidelines will make the industry and lawyers as well, and of course economists have a better understanding of this in the first place, understand the contours of what sections 3, 3, 3, 3, 4 and section 4 really allow or disallow. With that, I think we had an extremely instructive and interesting session. Before I hand it over to Bijayatri, I will just want to make one last request from all those who are watching. The last 3 months have really taken the greatest toll on those who have the least of the means to withstand it. Nature too has not been kind, and the cyclone Amphan has been devastating. You know, many of us are privileged to be cushioned from all of this. I ask you to dig deep into your hearts, if not deep into your pockets, and donate what you can to NGOs or government funds or even good human beings out there who are helping the poor. Let's all do something as human beings that we can be proud of when we look back when this crisis finally abates. With that, I hand it to Bijayatri. Thank you.
Thank you very much. We had a very wonderful session today. And I'm really glad that we had so many participants today at this time, of course. And there were wonderful questions that had come from our participants. So thank you once again to our participants for posting those questions for us. And of course, not taking much of your time because it's of course lunchtime for all of us. I would quickly like to extend my heartfelt gratitude and thanks to our distinguished speakers today, Dr. Geeta, John, Rajshekhar, Satvik, and of course, Anand. And thank you very much once again for collaborating with us at EBC Learning for this wonderful panel discussion on competition law and COVID-19 and after. It was a very insightful session, and Like Anand mentioned, I think it's very important right now that we all stay together, not physically, of course, because we're all maintaining social distancing, but in terms of connecting with each other as human beings first, and probably, try to help as much as we can. Nobody is asking us to take out whatever we have in terms of money or in terms of financial, putting forward in terms of um, helping out those in need, whether it's because of COVID or because of. Now, thank you once again to our speakers today. It was personally for me, it was a great session. I could learn a lot, and there were a lot of doubts that I have had regarding a lot of areas in competition law, which were very well discussed and dealt with today. So thank you very much. And with this, I'll close the session. Thank you very much.
Thank you.